Laws.com.
How to file for divorce in Hawaii. Step 1. Confirm eligibility. If you are looking to file a divorce in the state of Hawaii, then you will need to file the state's complaint for divorce with your locality's family court of Hawaii. You are permitted to file for divorce in the state even if your spouse does not agree to dissolution of marriage. Before filing, however, you must ensure that you fulfill the state's residency requirements. In order to adhere to these laws, you or your spouse must have lived in Hawaii for at least 6 months. If neither person has lived in the state for this time frame, then the court will invariably dismiss your case. Step 2. Filing divorce papers. If you meet the state's residency requirements, you may file your divorce papers to the judicial district where you or your husband lives. Divorce forms may be procured right here on laws.com or from the Hawaii State Judiciary website. Each island has separate forms, so be sure to procure the appropriate documents. The divorce petition will pose an assortment of questions to illuminate your specific wants and the roles of you and your spouse. On the form, you are required to elucidate the grounds for divorce and any requests you may have for child support, child custody, alimony, name changes, or claims to property assets. The legal ground for filing dissolution of marriage in Hawaii includes both no-fault and fault reasons. A no-fault Hawaii divorce will be filed if the marriage is deemed irretrievably broken. To secure this classification, the parties must live separate and apart under a decree of separation from any court of competent jurisdiction. The parties must also live separately for at least 2 years. After securing the appropriate forms, you must pay a filing fee to the state's judiciary. If the marriage in question did not produce any children, the fee will be $175. If the divorce is being processed with minor children, you will be required to pay $225. Claims for child support are determined through the income formula model, which calculates support obligations as a percentage of the income of the non-custodial parent. Filing fulfillment, the forms, as stated earlier, must be served to your spouse. Once received, your spouse may either accept or reject the intricacies of your proposed settlement. If rejected, further negotiations and possible court hearings will commence.
To watch more videos, please make sure to visit laws.com.